Hello friends, in the series on the income tax cases, today we will discuss a very important issue. In the regime of the faceless CIT appeals, whenever an assessment order is passed, sometimes there are arising a number of the appeals out of the same assessment orders. For example, if the assessment has been done and various penalties has also been imposed by the assessing officer, like section 271 subsection 1 clause C, section 271 subsection 1 clause B, 271F. So in these circumstances, the assessee has to file the various appeals against the penalty orders and the assessment orders. So the question arises that whenever these separate appeals are filed, whether these are allocated to the same CIT appeal or they may go to the different CIT appeal at different locations. The present case is Basant Sekhani versus Income Tax Officer, which has been reported in 108 ITR Tribunal, short notes 14. The date of the judgment is 1st November 2023 and the matter has been decided by Surat ITAT. The same issue has come in this case. In this case, the assessee was not well, his health was not good, he was suffering from slip disc, he was hospitalized, and when he was suffering, then notice under section 148 was issued to the assessee, and because the assessee could not reply with the notices, the assessment order under section 144, that is best judgment assessment, was passed, and consequently a number of the penalties were also imposed on the assessee. Section 271 subsection 1 clause C penalty order was passed. Section 271 subsection 1 clause B penalty order was passed, and section 271 F penalty order was passed. The assessee filed all the appeals against these orders. In this case, all the appeals were delayed by 350 days because the assessee got these orders very late. In the present case, the condonation was allowed by the CIT appeal as regards the penalty order under section 271 subsection 1 clause B and section 271 F was concerned. The condonation was allowed because these two appeals were allotted to one CIT. But the appeals against the order under section 147 and section 271 subsection 1 clause C was allotted to another CIT appeal who did not allow the condonation and dismissed the appeals in limine. Meaning thereby that on the same facts and circumstances, on the same appeals which were arising from the same matter, the appeals were allotted to the different CIT appeals who took the different stand in the different set of appeals. Meaning thereby that condonation was allowed in two appeals and condonation was not allowed in another appeals. When the assessee moved to the tribunal said that there was sufficient cause for allowing the condonation, and the ITAT said that in the present case, in filing the appeals belatedly, the assessee was not going to be benefited and there was sufficient cause for not filing the appeals in time because the assessee has submitted relevant documents about his slip disc and about the hospitalization. The ITAT also said that the ITBA portal, which allots the appeals to the different CIT appeals, should take an approach that the appeal should be assigned to the same CIT appeal which are arising from the common order, because by doing so it will help in the administration system, it will help in the delivering the justice to the assessee, and it will also help in concluding the matter more sensibly when the appeals relating to the same matter and same common order should be allotted to one CIT appeal. So friends, in this case the assessee has to suffer a lot because his 4 appeals were allotted to 2 different CIT appeals. One CIT appeal allowed the condonation and another CIT appeal didn't allow the condonation. So from this case it comes that the ITAT gave the direction that the CIT appeal from the common order should be allotted to one CIT appeal. At the end of this video, once again I am repeating the name of the case. The name of the case is Basant Sekhani versus Income Tax Officer, and this case has been decided by Surat ITAT, and the case has been reported in 108 ITR Tribunal, short notes 14, and the date of the judgment is 1st November 2023. Thank you, friends.